Chris Ryan is a long-term employee, been here almost 20 years, I think over 15. He has expertise in human resources, and I'll let him take it away.
All right, thank you, Dan. Like you said, I'm Chris Ryan. I am the West Georgia risk consultant. Little bit about me. I've been with the company almost 16 years now. November 1st will be my 16-year anniversary. But before that, I was 5 years county clerk, HR director, risk manager, safety coordinator, and office manager. So I understand how people have multiple jobs and multiple tasks to do. And a lot of times HR is pushed to the background, but this is the one thing that you need to look at as supervisors and make sure you're addressing it when it needs to be addressed and when it seems fit. A little bit more about me. My territory pretty much goes from Chris County to Carroll County, Chattahoochee to 75. I have a master's in business. I have advanced certifications in HR, human resources, and the county clerk certification through Carl Vinson Institute. What we're actually going to be talking about today is harassment and discrimination, but it's more on the supervisor side, just because we want to make sure you understand as a supervisor what your obligations may be, because they're a little bit different. I kind of talked through the process with employees, but supervisors need to understand what they need to do as soon as they find out that something like this is happening in their department or authority, city or county. So what I usually look at first is this: the cost of workplace harassment. In 2020, y'all, EEOC recovered $137.3 million for employees who had alleged harassment in the workplace. That's why it's so important to have everybody watching out for each other and make sure this doesn't happen or it doesn't progress past the point of trying to stop it at the initial point. The mental, physical, and economic harm to harassed employees is definitely immeasurable. It's extremely damaging and long-term, and it puts a stereotype on your city, county, or authority. And even the non-harassed employees have an impact on them, because all of a sudden they're thinking, oh my goodness, that happened to this person. Could it happen to me? And like I said, what we're having now is problems finding people to come work. And this is one stereotype you don't want to have put on your city, county, or authority. Workplace harassment can cause decreased productivity, increased turnover, definitely low morale, and a harm to your reputation. So the legal definition of workplace harassment is unwelcome and unsolicited conduct of a verbal, nonverbal, or physical nature. It is usually based on the protected classes that we'll talk about, and it's usually directed at that person because of that protected class. It creates an intimidating, a hostile, or offensive work environment, interferes with job performance, and adversely affects employment. So we're thinking about, how can it affect employment? Well, just think about some of the things that have happened. What we're seeing now more than ever is, yes, we still have the claims where somebody is physically grabbing someone inappropriate or asking for sexual favors, but what we're saying to each other is how we're getting into trouble now. And it could be as simple as this: I wish that old man would hurry and retire. He's just taking up space. Now, it sounds kind of innocent within itself, but you got to remember that is a protected class and it's violating the age law, okay? How about this one? You look nice today. Now, in Georgia, that's kind of natural. How you doing? You look nice today and stuff like that. But it depends on who you're saying it to and how they are perceiving it. It's a big difference in you look nice today and you look good in them jeans. Big difference there. Also, the frequency level is where we get into trouble about what we're saying. So you need to have their eyes and ears open, especially when you are supervisors, because as soon as you find out that this is happening, you've got an obligation right then and there, according to your policy, on what the next step should be. So simply having a policy is not enough, though. An employee must know what sort of conduct they cannot engage in, what sort of conduct that they don't have to put up with, and they definitely need to know how to report it. And that's very important, because that's usually one of the first questions I ask the employees. Who do you report harassment to? Now, of course, I've heard different stuff. Oh, your supervisor, HR, stuff like that. but they need to know that there is a thing that they can do according to the policy. Most policies actually follow a chain of command. Well, the only thing is, this is the one policy that could bypass chain of command. And all that's saying is that, especially if the supervisor was the one that did it to the employee's not going to go to that supervisor and ask them to stop. So you got to have other avenues to go to, and these employees need to know that. Sheriff's office, definitely, you may have to go straight to the sheriff. If it's anything that the Board of Commissioners is over, you may have to go to HR, the county or city manager or administrator. But you've got to have that in writing, kind of letting them know, and they need to know that. So if they have any problems, they know what needs to be done next. So the things that make us unique are the things we like to pick on each other about, because like, cities and counties are like big families, y'all. We love to pick on each other, but we have to know when to stop, and sometimes people don't. And it could be as simple as old man. Now, the reason I said that is because most of the time what I ask them is this: does anybody out there have a nickname in your department, and more people know that person by the nickname or their real name? And a lot of people say, oh yeah, we have nicknames. And my next question is this: can you tell me the nicknames? And sometimes they can, and sometimes they look at me and go, we can't tell you those nicknames. That'll get us in trouble. Well, if it'll get you into trouble, why are you still using these nicknames? And like I said, it could be as simple as old man, or calling other people different things too. If it relates to race, color, sex, religion, national origin, physical disability, all sorts of stuff, it could be found as discrimination and harassment. So we definitely need to be careful, even if something as simple as nicknames. So illegal harassment can be based on, like I said, the protected characteristics of sex, age, race, color, disability, handicap, creed, national origin, ancestry. And on June 26, 2020, sexual orientation was officially added in Georgia. Now, most of my cities, counties, and authorities already had it in their policies because we knew it was coming. But that's when it was officially added. And y'all, this is where we're having a lot of the claims, because people still don't know how to talk to each other about this topic. And it's going to be a learning process. And I'm hoping that the attorneys will start giving us a little guidance on what we can and can't do. And they have been, but I think we just need a little more training on that. So harassment is a course of conduct directed at a specific person that reasonably could cause emotionally distress in such person, and it serves as no legitimate purpose. What I usually tell them is this: one of the first things you'll ever be asked if you ever have a claim filed against you is, why did you do it? Please tell them to have a better excuse than, I thought it was funny, because I can assure you it's not, okay? It's usually words, gestures, and action tend to ignore, alarm, or abuse another person based on the mistreatment of a protected class, okay? And it's offensive because it's also against federal law, y'all, not state, not local, federal law. So if we go to court for this, which is very unusual, only about 10 to 7% of the cases usually make it to federal court. But if we do, we got to go before a federal judge and plead our case. And that is one place you don't want to be doing that at. So we talked about some employment discrimination. Now, discrimination can be intended against a group, which is actually called desperate treatment. That means it is focused on that group. That would be like this: the county, city, or authority says, what we're going to do is we're going to offer early retirement, but instead of giving the option to the employee to take it or not, they start pointing to people who should take it or need to take it. Now, that's usually taking the older workforce and pushing them out of the workforce. Yes, that is illegal, and you can't do that. Now, public services is a little bit different because they have different standards that they have to meet, but it is pretty similar. Or it could be unintentional. It still creates a desperate impact for the group. Now, that would be like this: the county, city, or authority says, we've got to downsize. Now, downsize is a bad word because a lot of cities and counties haven't had to deal with this. Downsizing is actually taking a group of people and getting rid of them. Now, you also got to think what is in that group of people? Who is in that group of people? And let's say the city county authority said, we're going to downsize and we're going to get rid of all of our administrative assistants. Now, typically, administrative assistants are female. Don't get me wrong. There are males out there, but typically they're female. So unintentionally, they may be going against a protected class of people when they get rid of this group. That's why you have to be so careful, even when it comes to something as simple as downsizing. All right, so Title VII Civil Rights Act of 64, it's enforced and administered by the EEOC and the Department of Justice. You must have 15 or more employees, which a lot of people already have, so we don't have to worry about that. But it prohibits discrimination in employment and employment actions against a protected class. And as of that point right there in 64, there was no individual liability. So the caps on damages with employees with 100 or less employees, there was 50,000 compensatory and 50,000 punitive damages. Now, back in 64, that was a lot of money. However, punitive damages could not be enforced on local governments. So you just had to worry about that 50,000 on compensatory. However, employers were solely responsible for any action that the employee did. So whether you knew about it or not, you were still liable. Now, also in Title VII, there was a retaliation. Title VII includes anti-retaliation provision like a whistleblower and Protection Act and stuff like that. So who's protected by this? Definitely employees, former employees, and applicants. It also, Title VII includes an anti-retaliation policy. And you need to remember that now they're actually telling us that the retaliation policy needs to be separate from the harassment section and everything like that. So there's a little bit of a difference there. So when it comes to retaliation, who can conduct, what conduct is protected? Definitely imposing an unlawful action, perceived or real, making a charge of discrimination, and testifying, assisting, or participating in the manner of an investigation or hearing when it comes to retaliation or harassment claim. Now, unfortunately, when that happens, a lot of individuals, employees think, oh my goodness, I just made a complaint. You can't do anything to me. I have a magic shield around me. So employers need to understand that this is not true. They're not immune to discipline. If they do something wrong and you would discipline a normal employee for this, you can discipline that person even though they had a charge of discrimination that they submitted. But a lot of people don't think that. You need to be sure of your actions based on legitimacy and a business-related reason. So always check with your HR. And for some reason, if they don't understand that we do have these wonderful things that ACCG and GMA are providing, and it's kind of like a hotline for HR issues, so they can kind of help you out before we do something that we shouldn't do, and it comes back and bites us. So definitely, the person shouldn't think they have that magic shield around them. Now, however, in 1983, everything changed, and it changed especially for Title VII because it was unique to the public sector. Now, it allows for individual liability, which means, and I tell the employees this, think about this, the city or county authority has done everything they know to do to make sure you know the policy and you understand it, and you do something anyway. And they're out of the lawsuit and it's related to only you. You can be charged individually in a court case. And look at this, the cap on damages is unlimited, no caps, y'all. That's why we hear a multi-million-dollar claim. So we definitely want to tell everybody that this doesn't need to happen in the work environment. It's good news for the public sector employees. It allows for qualified immunity. Now, so that means employers are not solely responsible for the action of the employees unless they haven't met the legal standards of going through the policy, training the employees on the policy, and definitely keeping them up to date on any changes. So now we're talking about the Pregnancy Discrimination Act of 1978, and it deals with sex discrimination to include pregnancy discrimination. It was an amendment that was made due to the Supreme Court decision because, unfortunately, what was happening before this, they would find out that a lady was pregnant and want to fire this person on the spot. You're my primary caregiver. We don't know if you're going to be here every day. We're going to go ahead and just let you go. Well, like I said, it made it all the way to the Supreme Court that changed it and said, yes, what it is this actually runs concurrent with the Family Medical Leave Act that says while a person is out having a child, fostering a child, adopting a child, or caring for a child, they can take time off and still come back to their original job. And of course, this it's unlawful for an employee to discriminate against an employee based on pregnancy, childbirth, and related medical conditions. But this also has made it to the side of the spouse, which means the spouse can take time off also to help do those things, adopt, care, or whatever for the child also. So I've got some cities and counties and authorities that they may have actually 2 people that are missing during this time, but it is a right given to the employees. Right? Equal Pay Act, it is part of the Fair Labor Standards Act, and it's limited to sex discrimination for wages. And it pretty much was paying different wages to employees of the opposite sex, where the employees do equal work, requiring equal skill and ability, but not being paid equally, or they have similar working conditions. And this is one, y'all, that I still don't understand. I don't understand how somebody can think that they should not have to pay people equally. And I see it more and more now, especially with entry-level positions where the lady is being paid below entry level. And my first question is always, why? And I always hear, must not be qualified for the job. Well, let's ask a couple of questions here. Did you accept the application? Sure did. Yep. Did they meet minimum standards? And that's a very key thing there. Minimum standards. They met those. So we interviewed and hired them. Now, since you've done that, this is something where you need to bring that person up to speed and pay them an equal rate. Well, before something else happens, we'll talk about that. There are defenses. An employer can pay men or women different salaries for equal jobs if it's based on seniority. Of course, if somebody has more years of service, they're going to make more money. Extra merit, extra certification, qualifications, or something like that. But there must be a factor other than just opposite sex. Enforcement, if this is found to be happening, it is upward adjustment only, y'all. Successful complainants recover back pay, liquidated damages, attorney's fees, and costs. So pretty much what we're doing is if we do this to an employee, just like harassment and everything else and discrimination, open up your checkbook and figure out how much it's going to cost to get this to stop, because this is not right. Now, on this one, there's no general liability or personal liability, and I don't think that's something that'll change because usually this right here is upper management making the decisions. So the Age Discrimination Act, you must have at least 20 or more employees, and it pretty much will say as if you are 40 or above, you are in a protected class now, okay? Now, under certain circumstances, local government employers can maintain mandatory requirement policies for public safety employees, but that's a whole different thing. And definitely, if you're thinking about something like that, you need to get with your attorneys. All right, so this thing also, the ADAEA claims subject to the same legal analysis as Title VII. It has the same causes of retaliation similar to Title VII. The only thing is there's no individual liability here either, and I don't think there ever will be. Now, damages on this stuff is back pay, front pay, liquidated damages, and attorney's fees. Like I said, this gets very expensive very quickly. So Americans with Disabilities Act, it prohibits discrimination of a disabled in both public and private sector. And it usually has the definition of what is disabled. So we definitely want to look at that. It bars discrimination of employers based on qualified individuals with disability in virtually all aspects of employees. So what's some reasonable accommodations? Because this is what it usually is based on. A reasonable accommodation without creating an undue hardship. So what do you think could be reasonable? How about this? It enables the disabled individual to perform the essential functions of the job. An employee must request the reasonable accommodations. Don't assume and say, do you need an accommodation? Let the person come to you and ask for that reasonable accommodation, okay, as a supervisor. Because as soon as you assume, then it turns over to a different aspect. Other reasonable accommodations, altering facility to make it more accessible. If for some reason you have somebody coming in and you don't have elevators to your second or third floor, you may have to come down and actually meet with that person on the lower level, the ground level, or you might actually have to put them in the office there on the ground level, or put in an elevator or something like that. Modified work schedules, and I've seen this before. An employee says, you know what, I cannot be here at 8 o'clock. Can I make it 8:30? Reasonable accommodation, everything's agreed upon. Yes, 8:30 will be fine. And some places cannot do that, and I understand that. But yes, 8:30. So for the next 2 months, they are 8:30 on the spot, ready to go, doing their business and everything. All of a sudden, now it's 8:40, 8:45. And you're like, wait a minute, they're not coming in on their modified work schedule. What do we need to do? Well, you can discipline that person for not meeting that reasonable accommodation they requested. So don't go to them and say, do you need another reasonable accommodation? That person needs to come and ask for it. And guess what? That reasonable accommodation the second time may not be a viable, reasonable accommodation. It's just something that you've got to think about. Check with HR so they can check with the attorneys and stuff and make sure that we're not giving them something that they should be getting. All right. Assignment to a vacated position, definitely not a real big problem, but a lot of cities, counties, and authorities don't have vacated positions or anything like that, or an extra position, and it's hard to do that. Qualified reader and interpreter, definitely reasonable. Some things that are not reasonable though, eliminating or changing the essential functions of the job. You have to be able to do the essential functions. How about this though, imposing an undue hardship on the employer or either jeopardizing the health of another employee. Definitely not a reasonable accommodation. So when it comes to any policies that come up, supervisors have always been the key for the implementation of those policies, and especially discrimination and harassment policies. The reason you're the key is because people take hints from you whether they think it's important or not. I've heard this too many times. Oh, HR just sent another policy to us, but they don't know what we do here, so we're not going to worry about that policy. Well, if there's a policy, then somebody has messed up to make this happen, and we need to make sure we're following all the policies. So definitely stand behind it and make sure the employees understand that you're standing behind it. All right. Retaining supervisors who do not fulfill duties under this policy is contrary, because why would you keep somebody if they're not going to stand behind the policies that you set forth, and it's just going to filter down? So how can we tell if behavior is inappropriate? Of course, would you want it to show up in your local papers? And guess what, y'all? We still have some places out there with local papers. Front headline says, city, county, or authority employee accused of harassment. Sells a lot of papers, right? The only thing is, if they ever have to retract that, it usually doesn't go on that front page because that's not newsworthy. It goes on the back page. How about this? Would you want it to show up online? And I tell everybody this, you know, everything online is true, right? And it's hard to get it offline. Is there equal power? That shouldn't matter. Subordinate, subordinate, supervisor, 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 subordinate. Wrong is wrong. If my spouse was standing right here with me, would I be talking to you like that, or you talking to me like that? Or how about this? Would you want somebody in your family to be going through what you're going through, or what you're putting someone else through? And are both parties initiating and participating equally? Like I said, wrong is wrong. So what appropriate corrective action do we need to do? We need to make sure we have a prompt and thorough investigation process. We get all the facts, y'all, both sides of the story. There's always one person, and the truth, and we've got to find out what the truth actually is to make a reasonable and an accurate response to it. Reach a conclusion, take action to correct the situation. And if that means you have to terminate that employee, it is better to go ahead and terminate that employee then than to prolong it. And I've heard this happen before. Oh, we know this employee needs to be terminated today, but we've got a big job and we need everybody there. So instead of us doing it today, can we do it Friday? And I'll do it about 4:30 on Friday. Wrong thing to do, y'all, because I can guarantee you, they probably know that they're on the cusp of being possibly let go, and they could cause other problems. So definitely any action you need to take needs to be done as soon as possible. All right, informing the victim of the results, because a lot of times what happens is somebody comes into the office or is talking to a supervisor and says, this is happening to me. What happens then? Okay. And then all of a sudden the next day they walk into your office, they're like, okay, look, you've had a day. What's going on? Well, the only thing is, you know, that doesn't happen that quickly. It takes time to do the investigation and time to talk to people. So what you need to do is affirm and let the employee know that you're taking this very seriously. And as soon as we know something, we will let you know, but not necessarily the penalty that was imposed. Okay, you don't have to tell them that, but just tell them the process that you're going through. Most employers felt compelled to err on the side of over-disciplined employee than worry about, if we don't do it, how bad can it get? And I've been doing this long enough to know that if somebody is harassing someone else, they've done it to other people too. Okay, it's not their first time usually. And for these little simple things that used to slip through the crack, like that single picture joke or email that gets people into trouble, and everybody just get a little slap on the wrist, don't do that anymore. We can't do that. We've got to make sure that we are disciplining people even for the small things so it doesn't get out of hand later. How about this one? Failing to report the complaint because, you know what, HR is just going to make a big deal about it, and we have a project deadline. Not the best thing to do. Like I said, HR is going to help you out to make sure that everything's being done correctly, and we're not going to have to come back and think about it again and possibly be in trouble for it. Telling the complainant to work it out with the other person. Please don't do that, because guess what? They might not work it out at the job. They might work it out in the local Walmart. And that's the last thing you want to have happen, okay? Bringing them in together into your office to clear the air. Definitely you don't want to do that either. This is something where you need to separate them and talk to them individually. I actually had a city that says, we bring them in at the same time. And I finally asked them, I said, why? Well, that person has a right to face their accuser. I said, in a court of law, not in your office. Don't do that anymore. Please don't do that. Talk to them separately. All right, doing nothing because the person complaining doesn't want to cause a problem. Unfortunately, as soon as you know about it, you've got an obligation to do and start the investigation and get the right people involved to make that decision at the end. And a lot of people say, well, I want it to be kept confidential. Well, there's no such thing as absolute confidentiality, because y'all don't have anything called a rumor mill, do you? I tell you what, when I worked for Sumter County, the rumor mill went from hardwired to wireless. A lot of times they knew I was coming to a location before I even got there. And it just happens like that, because as people start telling the story changes, and sometimes it can get a lot worse, but it's not always the truth. Transferring the person that complained without request. Last thing you want to do, because that person does have a little bit of a shield around them because they just submitted the claim. So you really don't want to transfer them. Now, if they come to you and say, look, would you please transfer me? Then definitely do it. But be careful about that, making sure that they request it. Failing to stop or make sure the problem is stopped. So not only do we have to stop it at the initial point, but we got to make sure it stays stopped. And sometimes that can be very difficult to do. All right, laws have changed and expanded a little bit over the recent years, but you know what? Lack of knowledge is no longer a defense, and employers must be proactive in not only preventing, but discovering and remedying harassment as soon as they know about it. So what are you, as a supervisor, what are your obligations? You definitely want to meet with the complainant, report and document everything. That's what we were told going through HR. Document, document, document. Everybody says, well, if it's not in writing, it never happened. Unfortunately, when it goes to court, everything comes out, and you don't want that to happen. You want to make sure you have it documented. Ensure cooperation with the investigation. Make sure there's no reoccurrence or retaliation. And definitely, as a supervisor, you need to support the discipline and the remedy. So when it comes to report and document, you want to name the complainant, name the alleged harasser, name the possible witnesses, because now we got to get witness statements from those people, date, time, and location of the alleged incident, and the description of the incident. Like I said, the more in writing, the better off it's going to be. And I usually tell somebody, look, I'm not crazy enough to know that it doesn't happen, because it does. If it's happening to you, write down what happened, who, what, when, where, and how. But I also stress, please, if the claim is not legitimate, make sure you don't submit a claim against somebody just because, and I've heard this too many times, I don't like my supervisor, I don't like my coworkers, and if I submit a harassment claim against them, it'll change their life forever. And it will, because even though they're found innocent with the investigation, out there in the public's eyes, they're still guilty. So I usually stress, if you are that unhappy with your job and your coworkers, it's probably time to find a new job. Ensure cooperation with the investigation. Don't assume that you're going to be the one doing the investigation, because you might not. HR may do it, the city, county, or manager may do it, or I've even heard of some actually going to a third-party administrator. So all they do is when they come in, they listen to nothing but the facts. They don't know anybody that's in the case, and they're making a judgment based on facts only. And that's kind of what we need to do also with us. And that may be hard because we know the people that it's happening to. That third party just has that to where they don't know anyone and they're just making a decision. Cooperate with and facilitate the investigation as much as you can, especially if it's in your department. Ensure that subordinates cooperate. So if somebody knows something, they need to come forward, because that can help us out and make sure that we give them the right corrective action that we need to give. And it's not just a slap on the wrist or something, but it's also setting precedent on what we do. Ensure no reoccurrence or retaliation. Make sure that you eliminate it at the initial point. Make sure everything's going okay during the pending investigation, but also make sure that everybody's okay after the investigation. It is not based on determination that the complaint is valid. We need to make sure that we're doing the proper steps when it comes to reoccurrence and retaliation, that this person is not having to go through what they've been through already because they submitted a claim. Ensure that all of the alleged harassers have rights and cannot be discriminated against. See, that can be difficult, because the first thing that happens, you try to push yourself away from that. But you got to remember that alleged harasser does have rights too. And just because a claim has been filed against them doesn't mean they did it. That's what the investigation process is for. And most cities, counties, and authorities know that if you have to do that investigation, it is easier to suspend that person with pay that the claim has been filed against. Pending the investigation, it's easier to bring them back, and that way they're not in the mix, so you can make sure you do a thorough investigation, okay? Support the discipline remedy. Just like any law or policy that we try to implement, supervisors are critical when it comes to making sure they understand what the discipline remedy is, and we stand behind it. And I've heard this happen too many times. Oh, I don't agree with what they did with Tony, but I guess I really can't say anything. Well, as soon as that comes out, all of your employees hear it, and they start thinking, well, man, I don't believe in it either. And it just causes a lot of turmoil. You've got to show support, whether you think it's right or not, because this is what the policy says to do. So definitely make sure you support it, because they will take keys and cues from you. So a couple of different, when it comes to workplace harassment, we usually put it in two categories. First one is called quid pro quo. Latin meaning is this for that. So it's an exchange of services, so to speak. The submission to or rejection of sexual attention is made implicitly or explicitly, depends on the vulgarity of the person. Kind of like this one. We had a guy who had 4 ladies working for him. Friday afternoon, he calls them into his office. He says, ladies, there's this raise I have to give at least one of you. Who really wants it? I'll be at my lake house all weekend. Now, you start thinking, oh my gosh, how did he say that? But he thought he didn't do anything wrong. But that simple statement got him into a lot of trouble. This can occur inside or outside the workplace, on or off the clock. So remember all those things like, I've heard this. Oh, what happens at training stays at training. No, it doesn't. I promise you, it'll beat you back. So make sure you're still representing your city, county, or authority when you go to training. Okay. And we had a situation where a supervisor took his administrative assistant to some training, which is not unusual. It happens a lot. And every night they would have dinner. Well, the only thing was, one night, supervisor had a little bit too much to drink and started propositioning the employee to meet them in the hotel room, and they promised them this promotion was theirs. The only thing was that person was videotaping the whole thing. And according to Georgia law, only one person has to know you're being videotaped. So we definitely got to be careful with that. And when you walk outside with your shirt or a uniform, or you get into a city, county, or authority vehicle, you are still representing that city, county, or authority. And we have to stress that to employees. So the best policy is what we usually say, you don't get your honey where you get your money. Definitely worth to live by. Now, there is a policy that city, county, or authority can implement to kind of help deter this, and it's actually called either a fraternization policy or no dating policy. And it pretty much will says supervisor-subordinate relationship should not happen. If it does, somebody may need to be fired. My interpretation is the supervisor is probably the one that needs to be fired because that person should have known better, and they went on ahead and did it anyway. All right, next one is hostile work environment. It's usually comments or conduct that is unwelcome. It's offensive to a reasonable person. Now, that's the standard that we normally use, a reasonable person standard. But unfortunately, it's based on the perception of the person being harassed too. It is usually severe and pervasive, regardless of intent and the frequency levels. That means it is done over an amount of time. Now, it can be so bad like this one though. We had a guy who had a unique way of welcoming you to work. He would walk up behind you, take his hands, slide into your pockets and move to the front of your body. Now, he thought that was hilarious. Not really, you know, but his interpretation was, I'm just trying to get their attention and I want to see what they look like when they turn around. Well, the only thing is, how many times did he have to pick himself up off the floor? And just because it was so severe and pervasive, it only took one time and one time only. All right, hostile work environment, harassment can be either speech or conduct. It's totally irrelevant. The intent, definitely when it comes to, it can occur, like I said, inside or outside too, verbal or nonverbal or physical, has a lot to do with that. So verbal side, comments, jokes, stories, not accepting no and asking a person out on a date. And you've got to remember this, if you have inmates that you have work crews that they go and do cleanup and stuff around the city, county, or authority, if they start doing this, you need to make sure you take them back because that could be offensive. That could be a workplace harassment, but it's going to be on the liability side, okay? And it can get us into a lot of trouble. So definitely, like cat calls and suggestive sounds, if you hear somebody doing that, it needs to stop as soon as it starts. Telling lies and spreading rumors, even if it's true. And like I said, repeated requests for dates or sexual favors. Nonverbal, gestures, body movements, elevator eyes, no direct eye contact. How about this? Suggestive visuals like your posters, your calendars, your pictures, your emails. And I'll tell you what, we'll say stuff in an email or a posting or something like that, or a text that we won't say face to face. So why would we say it in a text? And we never know who may receive that text or email that may find it to be offensive. So we got to be very careful with that one too. All right, so physical, we have hugs, kisses, patting, touching. All right, hugs. Georgia is a real big hugging state. We always have been, we always will be. okay? I'm not saying there's anything wrong with hugging, but if somebody says, please don't hug me, y'all just don't hug them, okay? And make sure nobody else is doing that, especially with COVID. A lot of people don't want to be touched. And we even heard of a situation where a young lady came into her office one day. And this day, the supervisor walks up behind her and starts rubbing her shoulders. Now, kind of creepy, right? Okay, but everybody that walked by her office saw this and didn't do anything about it. And after about a couple of days to a week, all of a sudden she would come in early. I'm talking about 2 hours early, run to her office and lock the door to keep the supervisor from coming in there. Well, the only thing is the supervisor had the key. Now, she is just distraught. She has no idea what to do. And now she's not coming in at all. And still people are going, oh my goodness, what happened to her? Why ain't she coming to work? Well, you knew what was happening and you didn't stop it. So I usually recommend to employees, if they see it happening, we need to make sure that we report it. So if a person feels like they're being harassed, a lot of times they don't want to come up because they don't want to rock the boat or don't want to cause any problems. But if you see it, even though it's called indirect, it's not happening to you, you still have a right to bring it forward also. And that's what we're hoping everybody does. You go and talk to that person and say, look, this felt like harassment. If you don't report it, I'm going to have to. And you got to stress this to the employees. Now, I do know that a lot of people say, oh my goodness, that means, the cases will increase and stuff like that. And it really doesn't. Yeah, it may tick up a little bit and more people start coming to the supervisor, but you as a supervisor need to just stop what you're doing. Please listen to them, and then based on your policies, what you're supposed to do next. And it could be you do the investigation and nothing comes out of it, but at least you're showing them that you're paying attention to them and you're not pushing it to the side. So how much is too much? Quid pro quo, one time only is all it takes. Hostile work environment's a little bit different. Usually, like I said, there's a frequency level that has to happen and stuff like that. And there's usually a pattern, but it doesn't always have to be because of it being severe and pervasive. Like I said, that case was. So who can be the harasser? Guess what, y'all? Anybody. Elected officials, managers, supervisors, co-workers, even employees. And how about this? Your citizens. Now, if we hear that a citizen is saying something inappropriate to somebody that's working for us or with us, we need to make sure that we address that issue as supervisors. Because guess what? You may even have that person come in and go, look, I'm going to have to talk to, let's say, Tony, Jim, whatever, and make sure he doesn't do that. And they're like, no, wait a minute, don't worry about that. I can handle him. We're just playing around. Well, the only thing is, if you say, okay, well, we won't worry about it. And 2 months later, this person comes into your office and says, look, I don't like where this is going now. And you've known about it for 2 months and didn't stop it. That's why at the initial point, we must stop it. Now, it's a little bit harder because usually when it comes to citizens, they're not in-house and it's harder to really investigate, but you still have to do your due diligence when it comes to that, even that, okay? Who can complain? Anybody, like I said, even a direct or indirect or unintended victim. That is somebody that's around when something is said inappropriately. That's why you have to tell your employees to be careful how you and what they're saying. If they would not say it in front of their spouse, their children, or their parents, why would they say it around anyone else? So tell them to use that little simple test to make sure they're doing something, or maybe even think to themselves, look, would this get me in trouble, before they open their mouth sometimes. Why do we create an effective harassment prevention policy? It helps us with our liability and reasonable care, remedying harassment conduct before it becomes too pervasive and severe, avoid lower productivity and morale associated with the harassing conduct, because like I said, it escalates very quickly. And usually if somebody's doing it to one person, they've done it to other people too. Avoid good employees from leaving, because all of a sudden they're like, look, it may happen to me next and I don't want to deal with that. So I'm just going to put in my resignation. And we're trying our best to make sure we keep the good employees, have a better work environment. And it's just poor public image. Elements of a effective harassment and discrimination prevention plan, it needs to be in writing or online. I know some people actually have their policies online. You need to define harassment and discrimination, declare what is intolerable. Now, are you going to get everything? No, but make it broad enough where it could include it. Follow a formal process, completed complaint process and reporting system. So if that person doesn't feel like they could go to their supervisor, they can still come and make a request that this is happening to them or a claim. Provide training to everybody, part-time, full-time, temporary, it doesn't matter. Everybody needs to be trained in this because anybody can have a claim filed against them. Make sure you have a prompt and complete investigation process and a corrective action and discipline. So, like I said, if it needs to be done, don't wait to do it in a later time. You got to do it as soon as you know it needs to be done. And like I said, the formal retaliation policy, it needs to be separated from the harassment and discrimination policy. So implementation of anti-harassment policy, provide to and discuss with employees upon hire. One of the things you need to check off your sheet when you're going through your policy manual is definitely this policy right here. Obtain the signature of the employee that they've read and understand the policy and your explanation. Policy should be placed in the employee handbook. It needs to be at frequent places where employees are at, maybe break room, time clock, training room. You're showing that it's a very important policy and everybody needs to know it. And consider that annual notice to remind employees. So what we actually say, the attorneys have told us that every employee needs to be trained at least once a year. Now, that doesn't mean that I have to come in and train the employees. Now, we can do that process, and it's a process that we'll go through after that. But you can go as simple as doing a webinar for the employees, or how about going over your policy at the different departments and offices and having them sign off saying that they understand it and they have no questions, and you're doing it yearly. And definitely this is something that the supervisors in those departments should say, does anyone have any questions on this? Maybe at a tailgate meeting or something like that. The more training you have, the better off it's going to be. Review the policy to make sure there's no updates needed, and sometimes there are. Communicate any updates with the employee themselves, so making sure that they know the updates. Have them sign for acknowledgement of it, and ask managers and supervisors to communicate it, like I said. Reasonable care and effective reporting procedure. In order to satisfy its duty of reasonable care, an employer must establish, disseminate, and enforce an anti-harassment policy and complaint procedure to make other reasonable steps to prevent and promptly correct any harassment that has occurred. Like I said, as soon as we know about it, we've got to take care of it. Keep the employees aware of the reporting procedures, implement those procedures effectively, prevent reoccurrence of the harassment by the same individual, have prompt, effective inquiry about harassment investigations. Don't push it to the side. This is something that needs to be addressed as soon as we know about it, and provide prompt corrective action against the employee who engages in this. And it could be up to, like I said, termination. So we have a scenario right here. Roy, a longtime battalion chief for a municipal fire department. For decades, he has employed a management style that promotes a family atmosphere at the fire station he oversees. In doing so, Roy casts himself as a firefighter father and the other firefighters as each other's brothers and sisters. In keeping with this management approach, Roy often hugs the firefighters, both male and female, at various points during their shift. Tanya, a recently transferred firefighter who had never previously worked under Roy's command, she is not a hugger and consistently pushes him away when he attempts to hug her. Roy is persistent in telling Tanya, you just need to understand that we're a family here. Family members hug each other, so you might as well get used to it. Tanya files a sexual harassment complaint with the city's HR director, who subsequently holds a meeting with the city manager, the fire chief, and Roy. Roy is told to stop hugging everyone. He responds by saying, I consider these firefighters to be my sons and daughters. I've been hugging them for over 30 years and I'm too old to stop now. So you may as well fire them. In exasperation, the city manager says, well, Roy, can't we at least get you to stop hugging the women? Roy is sad, but agrees to the compromise. From that point forward, Roy only hugs the male firefighters. whenever a female firefighter attempts to hug him, he pulls away and says, "Nope, sorry, women don't get hugs anymore." After several weeks of this, Sarah, a firefighter assigned to one of Roy's stations, files a grievance with HR alleging that Roy is discriminated against her and the other female firefighters by withholding hugs from them. Roy's in a bad place, okay? Danged if you do, danged if you don't. But you got to understand this. Everything that I've told you, all the stories I've told you, this right here are actual things that have happened, y'all. We're just changing some things so nobody knows where it's happened at. But these are things that we have to deal with on a daily basis. So we need to understand the signs and what we need to do after that, especially as supervisors. All right, since Roy hugged both male and female subordinates, was Tanya's complaint invalid? And definitely it was not. Y'all, she probably told him multiple times, "Don't hug me, please don't hug me." And she even went as far as pushing him away. Now he is grabbing her inappropriately without her permission, or just grabbing her without her permission, which could lead into a criminal charge, y'all. So it could go way beyond just a claim. Since Roy only hugged male subordinates after Tanya's complaint, was Sarah's complaint invalid? And unfortunately, hers was not invalid either. He was actually going against a protected class of people by not giving them hugs. Now, he was given a direct order, of course. You got to remember that. So maybe he might not get the blunt of the blame for this one, because the city manager was the one that said, "Please stop hugging the women." Okay, that's probably something that shouldn't have happened either, right? If the city had known for years that Roy hugged all of his employees, were his rights violated when he was instructed to stop? Well, a lot of people say, "Well, he's over the age of 40, so it's age discrimination." I was like, well, no, because there's no hugging law out there that says you can hug whoever you want to, whenever you want to. And always put this into it. What is considered welcome today may not be considered welcome tomorrow, next week, or next year. Things that were done 10, 15 years ago in the workplace can't be done today, so we have to change with the times. And unfortunately, Roy needs to change with the times. So could the city have handled Tanya's complaint differently? Definitely. The first thing they could have done is not have this last for 30 years, y'all. This is something that should have been taken care of way before now, but it hasn't. So we're having to deal with it. How about this one? Have a policy that actually says from this point forward, there will be no hugging on our premise, which means if anybody hugs, you got to go through the process of disciplinary procedure, and you would have to terminate people after they've went through the disciplinary procedure. Now that's a little extreme, but it can be done, okay? So there's a lot of things. Like, how could they have done it a little bit differently? How about this one? As soon as Roy says, "You know, I've been doing this for over 30 years and I'm too old to stop now, you may as well fire me." Unfortunately, Roy, we got to let you go. You're not doing what we're asking you to do to stop hugging. You're the issue, so we're going to have to let you go. Now, when that happens, do you think maybe Tanya may have some repercussions when she goes back to the office? And I'll go ahead and tell you, it's going to happen, so we need to be ready for it. So what you need to do, as the person doing the investigation, now you got to make sure she's not being discriminated, harassed, or retaliated against. And this is not something that could only take like a day or two or a week or two or something like that. This is something that could take years of going back and making sure this is not happening. Like I said, it gets very difficult, but it's something that we have to do. All right, so how about this one? Roy's not fired, and Tanya goes, "You know what? I quit." Case over? And of course it's not, because she can still come back and file a claim. And guess what? The problem is still there. So let's say that there is a male firefighter that comes back and goes, "You know what? Since Tanya had the courage to come forward and say she doesn't want to be hugged, I don't want to be hugged either." Now, see, the problem is still there because there's somebody not wanting hugs that he's not going to stop. So you never can tell what's going to happen. And I always stress this one. You're sitting at your office one day, you're a supervisor in that department, and you get a call from somebody and they're like, "How you doing? My name is Chris Ryan. I am the HR, I am the public works director, I am the sheriff, I am whatever title you want to give me of a county or city next to you. And we have a young lady named Tanya that wants to be an employee here, and she put y'all down as the last work reference, and you were the supervisor. What can you tell me about her? All right, that is a loaded question because, as you know, you need to make sure that your employees know that we don't need to answer these questions. The best thing to do, best thing to do is this. Hold on one second. Let me get you in touch with our HR department who can let you know any information about this person, or maybe even the sheriff or somebody like that, okay? Somebody in upper management. Because I've heard this too many times. Oh, don't hug her. Well, yeah, it's funny, but if you keep that person from getting that job and they find out that you're the person that said that, they can come back and sue you civilly. So the best thing to do is get that out of your hand and get it to the right people. And when HR gets it, we're going to answer about 3 questions, okay? Yes, this person was employed, the time frame they were employed, and a job title. And that's probably it. Now, a lot of people say, well, what about the question of, would you rehire this person? Well, the only thing is that is strictly straight from that supervisor, not the whole city, county, or authority. So if that person ever comes back, they want that person to come back and work for them. But it doesn't mean the whole city or county or authority wants that. So you got to be careful with that one. And a lot of attorneys say, don't answer that question. Now, if your attorney says it's fine, it's fine. But most attorneys that I've talked to said, just don't answer because it can get us into trouble. Like this. Would you rehire Tanya? Right there, without saying a word, I kind of gave you what I was going to tell you, but in a different sense. So that could get us into trouble, okay? Or how about this, even worse? Oh my gosh, Tanya was the best employee we've ever had. Oh, I was sad to see her leave, but I'm glad you got her now. Click, not my problem anymore. So you're giving a good recommendation for somebody that shouldn't be getting. Not saying Tanya doesn't deserve it, but you know, unfortunately, we sometimes pass along to people we don't want to deal with anymore. And that's the last thing we need to do. We need to make sure we're protecting not only our city and county and authority, but others too. So like I said, just get it out of your hands, get it to the right people, and make sure they understand. All right, any questions? Dan, any questions from the group?
Any questions out there? I don't see any, Chris.
Okay.
Couple notes, so I think we're in good shape.
Well, like I said, if anybody has any questions, please feel free to email me or email Mr. Beck, and he'll get them to me, and we'll answer any questions you may have. But besides that, I greatly appreciate it. I definitely hope you learned something, and thank you for your attendance.
Again, we will be sending out a recording of or a link to this. If you have any questions, please let us know. Thank you so much, Chris, and thank you everybody that attended.
All right, thank y'all. Bye.